Thanks again for joining us, and I hope you enjoy your evening with us. So good evening, everyone. It's a great pleasure to welcome you here to this Accompaniment in Action event. We've been running this series now for a little while, and we've covered many interesting topics, I hope you'll agree. And this one is set to be continuing in that vein. So we welcomed the legal project of JRS to speak to us, I think just at the end of last year, and they gave us a bit of an introduction into how the asylum system works. And so we're going to build on that this evening. We hope it'll still be accessible to you even if you missed that last event, although we'll make a link available for that if you wish to catch up after seeing tonight's episode. But we will be going over what the work of the legal project and how they support our refugee friends in making fresh claims for asylum. So to discuss this with me this evening, I'm joined by Michael Tarnoky, who is JRS UK's Senior Legal Officer, and Jess Javaherian, who is our Senior Legal Caseworker. So I'm going to hand over to them.
Hi, good evening. I hope you can hear me properly. So for this accompaniment in action, as Nick said, we're looking at fresh claims. We wanted to do this because this is the area of asylum law that our refugee friends here at JRS need most assistance with, and it forms a very large part of the work of the legal project team day to day. In fact, most of today we've been working on one that's come up rather more urgently than we expected it. I'll hand you over to Jess.
Good evening, everybody. So I'm just going to give you a brief overview of what we're going to focus on this evening. We're firstly going to look at exactly what a fresh claim is and what the legal test is relevant to a fresh claim. We're going to then go through the basis of a fresh claim, how we prepare it and how we think it should be prepared, how it's submitted, what happens once it's submitted, and then also look a little bit about securing legal representation.
So, what is a fresh claim? Well, the first thing is that the Home Office call it further submissions now. A fresh claim is an opportunity to give new evidence to the Home Office and to ask for a new decision when your case has been all the way through the courts, when people are what is often referred to as appeal rights exhausted. All the people we support at JRS are appeal rights exhausted asylum seekers. The Home Office started calling it further submissions a few years ago, and they, but in terms of what people commonly talk about, they talk about a fresh claim. I guess one way of looking at it is that you make your further submissions and then the Home Office decide whether they amount to a fresh claim for asylum using the legal test that Jess is going to set out now. Oh no, I'm going to set it out. So we put up the legal test on the immigration rules, from the immigration rules. And the key things here are that the test determines what happens to further submissions, not just if they're granted or not, if they grant leave or not, because a lot of people, when they put in further submissions, the decision isn't going to be to grant them leave. It's whether they'll get a right of appeal, whether their case will go back in front of a judge because the Home Office decide, okay, we're not going to grant it, but we can see that this is arguable, and so notwithstanding its rejection, there's a realistic prospect of success. So Jess will take you through that in a bit more detail.
So the first part we've highlighted from the legal test is about the new evidence, and the test states this has to be significantly different from the material that has previously been considered. So the new evidence here is the main point to highlight. We're going to look at each of these points in more detail as we go through the presentation. But effectively it's new evidence which supports the original asylum claim. This could be specific to the applicant themselves, which we'll look at in a little while. Also changes of circumstances in the applicant's home country. There could be new evidence relevant to that which would affect their possibly make a further submission, a case for further submissions. There could also be case law and legal developments, which could also be new evidence to put forward a strong fresh protection claim. The evidence doesn't actually have to be new in itself, but must be newly available in the particular case so that it hasn't been considered before by the Home Office or by the tribunal. The next part we've highlighted is that the new evidence is taken together with previously considered materials. So one thing to say here is the principle behind this is if the judge could see the new evidence you're submitting, would they have agreed with you, with the case that you put forward, and would they have allowed your appeal? So the Home Office, when you put in further submissions, will consider the new case, which will set out what that is formulated of later. Also any previous witness statements, any previous evidence, and also any case findings as well. So the new evidence is considered in relation to all of that. There may have been previous adverse credibility findings. So this is where a judge may say that they didn't sort of believe a part of your case. If these findings can sometimes be not very focused and very precise, so it can be quite hard to overcome negative credibility findings. But if new issues are very different, then previous findings of fact shouldn't be so important. But if there's a general finding that someone hasn't told the truth or that they're not a truthful person, then this can be held against them in relation to any fresh claims. So we'll talk a bit about how independent evidence can back up possibly earlier testimony to demonstrate that what you were saying at your initial case was true. And we'll look at more examples of how this works when we look at how a case is prepared. The final bit of the test that we're going to pull out is a realistic prospect of success. It's important to convey here that this is a low hurdle and it actually means not fanciful. So you don't have to prove your case, but only show that it's arguable. The evidence, the new evidence must be relevant to the individual's situation and also relevant to the individual themselves. So whilst we are looking at the legal test for further submissions, we also have to apply the relevant legal requirements for a protection claim. So in the last webinar, we looked at the definition of a refugee and the Refugee Convention. So the evidence must help make a strong case for protection, and we would hope that it would help evidence, for example, a well-founded fear, the convention reason, and other elements of the Refugee Convention. I'm going to look quickly at just this flow chart, which sets out what happens after your appeal rights exhausted. So that's when your initial asylum claim has been refused and you've gone through the appeals process. Then that's when a fresh claim could be made. So when it's submitted to the Home Office in the first instance will consider whether or not it meets the fresh claim criteria, which we've just looked at. They may decide in the first instance that it does not meet the criteria, in which case the only remedy there would be a judicial review, and further legal advice would be required at that stage as to whether a judicial review is a viable route. Or they may say that it does meet the fresh claim criteria, and having considered the new evidence, they give a positive decision and they grant leave. Or in the alternative, there may be a negative decision and the claim is refused. In those cases, we would hope that there would be a right of appeal, and then there would be further advice given at that stage about sort of prospects of appeal and grounds of appeal.
So, when we're looking at a fresh claim, the starting point is to look at why the initial claim was refused. And there's a lot of reasons why cases fail. Sometimes it's because they're badly prepared, that people were unrepresented. And when you're looking at it again, that's not enough on its own, but it will assist in showing why any new evidence wasn't submitted or why arguments weren't put forward. We can advise and show how it might make a difference. In some cases, people were just unlucky. But generally, when we're looking at cases, we can see that the country evidence wasn't there. Now, that might be because evidence was there, did exist, but wasn't submitted, or it might be that the situation, as we'll look at later, had changed a bit, and there may be new objective evidence relevant. A lot of cases we'll see where there was no medical evidence for some reason, either poor representation or late disclosure. And there may be cases where a medical report could help evidence things such as scarring or physical evidence of torture that will back up an accountable treatment that previously hasn't been believed. There may be diagnoses such as PTSD, or there may be medical evidence to show that past trauma has led to difficulties of recall or giving evidence that has led to a claim failing. There's a couple of very specific things that the Home Office will use to find people's cases not credible or to dismiss people's cases. One particular thing is language analysis. So where people have claimed to be from a particular ethnic group or from a particular country, the Home Office have relied on reports produced by agencies that have since been discredited. So there may be cases where this could be used to allow new evidence or to undermine previous findings about people's nationality. And again, the Home Office also dispute nationality on other reasons, such as what are basically general knowledge quizzes about a country. And often their conclusions have been inappropriate and sometimes even incorrect. And it may be that these could have been advanced but weren't because people's cases weren't properly represented or because those particular issues were ignored by judges. Generally, when we're looking at these cases, there's an adverse credibility finding. The judge has said, I don't believe this. I don't believe you. I don't believe this happened. I don't believe you or the person you say you are. So we'll be looking whether there may be documentary evidence, proof of membership of a political party, new witnesses, that sort of thing, that could overturn it. But the other thing that is really important that when we're looking at fresh claims is a change in the applicant's personal circumstances. There may be issues that have changed completely, or there may be people who are, after many years or having some space to think and reflect, are able to fully disclose their personal circumstances. And this may be issues about genuine religious conversion, assertion of sexual identity, genuine political activity. The Home Office are always going to go, we don't believe this. There is a culture of disbelief. We need to be straight up with this with our refugee friends and make sure they understand what they're up against. So we will need to provide evidence. And as Jess said before, where a judge has said, I don't believe you, then the Home Office will apply that to what was said in court on the day 10 years ago and what's being said now, even if we've got all sorts of evidence and witnesses to show that it is the case. There may be reasons why people were unable to disclose things, perfectly good reasons. There may be medical evidence or other things that we can put forward to explain why the person didn't feel safe to disclose the initial claim. Or there may be, or it may simply be that it wasn't the case at the time, and now we're able to bring this evidence. It has to be said that there will be previous findings that may be positive, that may be useful, and we need to be aware of those and to make use of those if there were positive previous findings. The other big change of circumstances will be in the world around us, the world that the applicant has come from in their home country. That could mean that they're now clearly at risk. There could be a change in government that means that someone who previously wasn't at risk now is. There could be new laws that are introduced in their home countries. For example, in Eritrea, where laws are introduced around draft evasion and the legal exit, or in Uganda around sexuality, or new implementation of laws. There could be increased political conflict. That most of the countries that our refugee friends come from have some level of conflict. The Home Office normally tend to play it down, but we may be in a situation where a judge previously would have said, well, the situation is not so bad, and now clearly it is. The other change of activities may reflect, change in circumstances may reflect activity here. So what's called surplus activity, usually around political activity. Many refugee communities and migrant communities have lively political opposition groups, and they often do attract the attention of the governments of their home countries who don't like people opposing them from abroad, and there may be people taking part in legitimate political activity may find themselves at risk. The other things that change, that give a basis to a fresh claim, could be changes in case law and legal developments. So where a judge has found that some positive findings of fact, but it's decided that this doesn't fit someone into the convention or doesn't make them a refugee, then we could now be using the same findings based on new case law. So for example, country guidance case law, where the tribunals decide that there should be protection given to people who are members of particular political groups or people who fit a particular profile, either ethnically or politically or in terms of their own religious beliefs or sexuality, for example. It may be the case that it's clear that the tribunal or the Home Office have misunderstood the law or misunderstood the objective evidence, and being able to apply expert evidence and expert commentary on findings that they've made may be enough to bring a case that now does have a reasonable prospect of success. There are changes in Home Office policy and procedure that usually as a result of legal challenge that have also meant that people whose cases have previously failed should be able to make new applications with the hope of a fair hearing. For example, people whose cases were processed under the detained fast track, then the Home Office have had to accept that no, that wasn't good enough, that people didn't get fair hearing. And if people are still here, then it may be possible, notwithstanding all the other issues, to make fresh claims at this point. And finally, there does happen that the court or sometimes the government will decide that the situation in a country has deteriorated so much to such an extent that people should be protected, not necessarily under the Refugee Convention, but across the board protection, as has happened with Libya in the last few years.
Thank you both very much for that introduction to what the fresh claim actually is, and the legal test that must be met by any fresh claim, and on the basis of which fresh claims are made. Jess, I'm wondering if you could explain a little bit more about how a fresh claim is actually prepared.
Absolutely, Nick. So it's extremely important when preparing cases that you gather all previously considered material. And this is why cases need so much preparation, so that we know everything that's been said and submitted before, so that we can consider new evidence and discuss new evidence and then advise on prospects for a fresh claim. So one of the first steps we take is to make what's called a data subject access request. And this is where, with the authority of the person, we ask for the full records of the Home Office. So this includes interview transcripts, audio recordings, previously submitted evidence, witness statements, detention records, court records, any previous decisions taken from the Home Office and from the tribunal. There's normally a large amount of papers, and some people we advise don't have access to the previous papers or the previous evidence. So one of the first steps we take is to ask for these records. People might be aware that there was a data protection immigration exemption, which is the Court of Appeal have handed down a judgment now ruling that unlawful. So that was to try and control how people could access the data when it's in relation to sort of immigration and sort of immigration control, but that has been ruled unlawful. So hopefully there won't be those restrictions on access to the data which we need and which is very important for preparing a case. So we thoroughly review everything that comes through and then meet with whoever we're advising to discuss the past case and discuss the new evidence or new evidence that might be newly available.
So ideally, people should have a legal representative. These are really complex cases, and the legal representative needs to have looked through everything that went before and then take new instructions and find out whether there's new information. I think it's really important that they're able to identify that there is still a refugee claim. Some people have been here such a long time that it's very difficult to show that there is actually a refugee claim still valid, regardless of why someone originally fled their country. It's important to be able to explain and take the time to explain why the old decisions are so important. Many refugees will completely rightly feel that they've been ignored or treated unjustly in the past, and that it's important for people to understand why we can't just ignore that. We can't just say this was wrong, this is the new claim. We will need to confront that if we're going to succeed. And then to be able to work with them to look at what sort of new evidence may be available to them, whether it's evidence that we're going to find, which we'll look at in a minute, or things that they should be able to come across. And identify the positive findings. You know, if there are positive findings, then it's good to be able to say, this was good, we can build on this. And we need to be able to give them a really, really clear as possible, indication of the prospects of success. Because it's not fair for people just to be told, yes, we'll make a fresh claim, this is fine, everything's going to be all right. We need people to understand the delay, the work that's going to be needed, what they're going to need to do, and how things are going to play out, or might play out, whether there's enough to make a fresh claim. And if there's not, we should be looking at what other applications are available. I've spent a couple of days making European Union applications for people who, in my view, are clearly refugees, but they're going to succeed on this a lot quicker than any fresh claim would go through.
Okay, so I'm going to look a little bit at the types of evidence that may be available or can help prospects for further submissions. One of the most important pieces of evidence can be witness statements. When we look back and review a previous case, it may be that a statement might not have gone in, or for example, at initial interview, there could have been an issue with interpreters, but the person being interviewed was extremely worried, understandably, maybe didn't understand the interpreter, or maybe was really just so concerned and anxious at the process that their case didn't maybe come across as they would have wanted to. So something that we can look at is sitting down and spending time and going through their case and talking to them about that, so that we can put forward a very detailed statement. Also, to clarify if there were any misunderstandings in the initial claim, if we go through the initial interviews with them, it may be actually when the interview's read back that they don't agree actually with what's been written, or how the claim's been interpreted. So we can spend time going through that with them, and then maybe even evidencing some parts of that statement as well. So that's a really important part. And sometimes someone can give independent evidence as well in relation to their case. Some people are willing to write statements and also to attend hearings if they go to appeal, and this type of statement and evidence can be really beneficial. In certain cases, we also look at whether there's any documents available to verify somebody's protection claim. So, for example, if there's a membership to a certain political group, is there a membership card or something available, or something that can be obtained? It may be that in certain circumstances it's really not safe to do that, and obviously then it would be for us together with the person whose case it is to explore that and to put forward maybe some objective evidence about why that's the case in this circumstance. The document verification is important, and if possible, it can help strengthen a case. In some cases it's very difficult to do, and experts aren't actually willing to verify documents, possibly because there's no sort of set format in the country where the document's from, so it's very difficult to actually verify it. The Home Office does carry out document fraud checks, and unfortunately there is a general culture of disbelief. So the Home Office tend to be or can be dismissive of things like witness statements, and can sort of rule them as self-serving, even though we're submitting that they are important to the case. Other documents we can look to get are birth certificates and baptism certificates. These can be very beneficial in relation to nationality disputed cases. Also, it may be that there were a sort of arrest warrants, active arrest warrants still outstanding, that copies of those can be obtained, but again, in some cases it's just absolutely not possible. So these are all things that we'll talk about and explore. Again, if it's safe to do so, and if it's not, then statements and objective evidence about that are very important. We also look at expert reports. So medico-legal reports can help to explain and evidence part of someone's case. So, for example, where there's been torture or scarring or post-traumatic stress disorder, which could also affect sort of memory issues and recall of a case, then a medical legal report can help. The expert will work with the applicant and help to put forward a report which evidences what they've, in their expert experience, have explored with the applicant and their expert opinion. Similarly, country expert reports, where an expert can write a report specifically to an applicant. So they will talk to them about their individual circumstances, for example, where they were from, specifically in that country, what their case was, and then they will write a report based on their experience in that country related to the applicant's case. There's also other evidence which I've touched on, which is objective evidence. So this can be things like reports and articles from places like Amnesty, Human Rights Watch, various trusted media sources, and there's really great sources for objective evidence, and they can help to really show the Home Office and the Tribunal what's actually happening at the moment, and then we can relate that back to our friend's case. In certain cases, I should add that there might be evidence that's available that actually wouldn't be necessarily helpful to a fresh claim. So, for example, a baptism certificate for an Eritrean national that predates Eritrean independence. In cases like that, then we sit and discuss it all with the person whose case it is, and we'll take a clear agreed decision on whether it's best to submit that document for that case.
Okay, so I'm putting myself a little bit in the shoes of one of our refugee friends. So I've been working with you. We've decided that I perhaps have a fresh claim which was worth pursuing, and we've spent this time preparing the evidence together. How would I go about actually submitting that fresh claim? What's the next step?
So there's a Home Office form, which is a further submissions form. It's just very basic evidence. So we tend to fill this out with basic information, and then it's ideally, if you've got a legal representative, and this is what we do in our cases, we write a substantial letter of legal representation which outlines the case, the law, how the evidence is relevant, how the fresh claims test has been satisfied, and how the evidence and submissions show that the individual should be granted leave. So this is normally a substantial document which also accompanies the new evidence, and also any translations and verifications of that, together with all objective evidence. So once that's all gathered and our refugee friend is happy with the case, then we submit it. So it used to be that the Home Office would require our friends to attend an in-person interview in Liverpool in order to submit a claim in person, to submit a fresh claim. And it was only in rare circumstances that actually they would make people exempt from that. So if they were heavily pregnant or unable to travel or had a child or they were detained. We used to spend hours on the phone trying to get appointments for the further submissions unit in Liverpool. And in our experience, it didn't add anything to the process. It just seemed to be a barrier to submission. During COVID, the Home Office has been allowing submission via post and email, which was much better, and we were really hoping that that would continue. We've recently heard that the requirement for in-person appointments will be coming back. They've not indicated when. The Home Office hasn't indicated when. They've said shortly, and possibly with more locations, for example in Glasgow. So we are very disappointed about that. And so once the case has been submitted, then it may be that the Home Office require a further interview. This could be in cases where an initial asylum application had been made previously, but then the person might have absconded or not been available for interview. So it might be that an interview is required then before a decision can be taken. It might also be if there's been big changes. So if there's a personal circumstance change in relation to the further submissions, it might be that the Home Office want to conduct an interview there, for example, religious conversion cases. If there is an interview or not, then the Home Office will consider the case and then make a decision. This can take an extremely long time, which is obviously very frustrating. And we have to wait for a decision. They might sometimes ask for some further information, but we obviously hope the decisions are made as quickly as possible. Whilst an applicant can't be removed from the UK before the Secretary of State has considered the further submissions, and they will look at, as we said earlier, the new evidence and initially decide whether it meets the criteria and then whether leave should be granted. So I'll go on to that. That's it. So I think we're going to be posting a blog shortly, actually, about decisions, which will go into this a bit in a bit more detail. But this is a repeat really of the slide from earlier, but just to remind, so what happens after the further submissions have been submitted. So the Home Office will consider initially the test, so whether it does meet the fresh claim criteria or it doesn't. If it doesn't meet the fresh claim criteria, then it may be that there's a possibility for judicial review. If it does, then there may be a grant of leave on the new evidence, or the claim might be refused, in which we would hope there would be a right of appeal so that we can go before a judge. Okay, so moving on to, so I'll just look now at exploring securing representation. So unfortunately, so the refugee friends that we help have all been appeal rights exhausted. So they've all had previous asylum cases that have been refused. Unfortunately, many people have previously received poor advice, which will have been detrimental to their current and future applications. So in our experience, there is a shortage of reputable immigration lawyers, and also the standard of immigration advice and representation varies greatly. We, JRS, don't have a legal aid contract, which Michael will talk about later, but many places do have legal aid contracts, and there are funding issues in relation to each case, and also many sort of administrative duties in terms of securing the funding, which can detract really from the time that can be given to the cases. There's also not enough matter starts for legal aid cases, which is firms and law centres are allocated. They're called matter starts to allow them to start new immigration cases. Then there aren't enough actually for initial applications, let alone fresh claims or other cases. Some, in our experience, some advisors do take advantage of people as well, providing poor advice and charging for it. So where we can, we try and meet with as many people as we can, and even if we can't do a full case, then we'll at least try and give some initial advice, so to avoid sort of people getting bad legal advice and being charged for it. The number of people we find requiring assistance outweighs the number of reputable advisors, and also many cases do require firms the legal aid contract, because this can help cover disbursements where, for example, you need a medical report or an expert report. Some legal aid firms just don't have capacity because of the legal aid sort of requirements. And unfortunately, again, many places are facing closure due to funding issues.
So the JRS legal project was set up very much with the JRS mission to accompany, serve and advocate in mind. And we are very aware from the start that the key work that was needed in the sector generally, but specifically for our refugee friends, was to have capacity to work on fresh claims, on looking at what had happened in the past and trying to see whether we or somebody else would be able to restart someone's case to put in a fresh claim. And we worked without a legal aid contract, and to be honest, I think that's the reason why we're able to function without the administration and restrictions, but also it means that we can spend a lot more time with our friends to understand their case and to take detailed instructions, and to work with them when they find it very difficult to engage with legal representatives on the terms of the legal representatives themselves. We can engage with them on their terms and work together, and that's really important, because as you can see from what we've gone through already, then one way or another, none of our refugee friends will have had good experience of legal representation. Even if they've had good legal reps, then their experience of it won't have been great. So we're able to work with them and try and build a case. Sometimes that'll mean we prepare the case and we submit it. We've done quite a few already. Sometimes it will be just making sure people understand what's going on, and then being able to look at what steps can be taken next, and either referring out to other providers. And one of the things that was flagged was that the legal aid providers can at least recover costs for things like medical reports and expert reports. So where a case is going to turn on that, or where we know the case is going to go to appeal or go to judicial review, then we'll be looking to refer out to legal aid providers and to support our friends to engage with them, to make sure they understand why we're doing it. We're not doing it because we don't like the case, but because that's where the case needs to be. That's the sort of capacity that the case will require to succeed. We're really lucky here that we've got the connection with other parts of JRS, with being able to turn to volunteers and for support with accompaniment to embassies, to gain documentation that will go to approve or disprove parts of the case, supporting people with going to reporting when that restarts, because that can be very traumatic. Even if there is in fact no risk at the time of detention or removal, then when people are appeal rights exhausted, then it can prove very, very traumatic. And then ultimately, when we are able to submit further fresh claims, and if it does become a requirement to attend a further submissions unit in person, then accompaniment to that is obviously going to be a great benefit to our friends. And all through this, we work really closely with the destitution team and our emergency support team, so that we're able to identify cases that need urgent attention, and we're able to advise on risk and the likelihood of the possibility of a fresh claim being made, and what steps need to be taken to set that up. Obviously, we're in a position where there's myself and Jess, and we've been really lucky to have Bernadette working with us over the last year. So we're not able to do anything like the amount of work that we'd like to, but we are, I think, able to provide some capacity to fulfil JRS's mission. I think we're done now, and we've got time for questions.
Thanks very much, Michael and Jess. I think my internet cut off there, so I apologise if the slides disappeared. There's always time for one technical glitch, I suppose. So yeah, we do have some time for questions and answers now. As you'll see, there's a Q&A box there for you to ask away with your questions. So please do type them in there, and we'll try and get through as many as possible. Michael and Jess, just while people are getting their questions in, one of the things that I'm sure lots of people would like to know is, are people supported in any way whilst they are submitting a fresh claim with, say, perhaps financial support or any sort of accommodation?
Yes, so once people submit further submissions, then they can become eligible to apply for what's called Section 4 asylum support. So this is usually a very small subsistence payment and some Home Office accommodation provided together. The Home Office accommodation is always very basic and, you know, sometimes below standard, as we've experienced, and many of our refugee friends find themselves dispersed also outside of London. So we do advise, actually, once further submissions have been submitted, and our destitution team also help support friends with our help and advice as to whether in their circumstance it might be the right thing or not to make. But there is something available to apply for, but whether or not it's best in that person's circumstances will sometimes vary.
So we've had a question here from Cashel, who's asking about, is there sort of a length of time that people can claim asylum or can be recognised as refugees within? I think you said mentioning earlier on about they've been here for a long time, so they might not have a good chance of being recognised as refugees. Perhaps you could touch upon that, Michael.
I think it's entirely fact sensitive. So someone could be here for years and years and something happens in their country that would make them a refugee, or they could be somebody who arrived a long time ago and should have been recognised as a refugee, but the circumstances in their country have changed, the government's changed, the reasons why they fled are no longer valid reasons, they're just no longer there. And so they would have difficulty maintaining a refugee claim. So there's no legal cut-off, there's no time limit, or one way or another that you would be a refugee afterwards or wouldn't be. In practice, for most of our refugee friends, the ones that have been here a very, very long time, the issue is not necessarily whether there's a risk of persecution now. It's that they're simply not going to be removed to anywhere anyway, and it's about resolving that more than anything else. Though that's an entirely different issue, it has to be said. But no, there's no period that would automatically be a cut-off, and there's no it would be entirely fact sensitive.
And we've had a question here from Ruth, who's asking you if you'd be able to explain a little bit more about the situation.
Okay, so these are, we had a number of our refugee friends have got children who, because of the way British nationality law works, are British by birth. So if someone is born in the UK to a settled father, then, or a settled parent, in this case the father usually, so either someone who's got British citizenship or who's got indefinite leave as a refugee or as something else, then that child will be British. And there's quite a few of our refugee friends who are in that position, bringing up their kid on their own. They've got no status here, but their child is British, either because they've registered as British or because they were born British. Now, until very recently, it looked like those people would be making applications through the immigration rules, which are lengthy, complex, and the end result leave isn't great. But a recent case in the High Court has confirmed that that a British child that was born before 31st of December, and where there's a primary carer whose removal would mean that that British child, who we would define as a European child in this case, would have to leave the territory of the European Union, then that mother can make an application under the EU settled status process that's been in the news a bit because the deadline was today. So we had been identifying those of our refugee friends that were in that situation and ensuring that either they had representatives who are taking that step, because the ultimate, what they'll get out of it is ultimately settlement, and or if they didn't have representatives who are taking that step, doing the application today, well not today, yesterday, I think we did our last one, but we had a fairly short window to track people down, check that they were represented and do the applications if they weren't represented, but hopefully they'll get good results. It's the ultimate leave is probably on a par with being recognised as a refugee, but the process will be, I hope, much quicker than for some of them going through a fresh claim, which may not have been successful, but this is a better outcome at this stage.
Thanks very much for the clarification. I think that also touched on the point of how, first of all, how complicated lots of this is for those of us who aren't trained to do so, but also the benefit of having someone like yourselves to be able to talk through the process with our refugee friends who otherwise might not be able to have access to that sort of information and therefore wouldn't have been able to put in a a claim for that particular case. And obviously that will have a big impact on that family as well. And you see the knock-on implications of that. So thanks very much, Michael.
Just add to that, yes, we did some tracking down, but our destitution team, they seem to know everybody and would be coming to me going, this person's got a kid, are they British? So the fact that we have a huge family here that knows everybody's private lives, it kind of played out well for some people in this case.
I hope that's something that's coming through as we do more of these events, where we sort of look at the very broad spectrum of things that JRS UK have started to do, and we see the way that actually everything is interlinked, that, you know, we're able to offer quite a holistic service now to our refugee friends and accompany them in many different ways. And so that the people who might be coming to you for legal advice and hopefully making a positive step in towards being recognised as refugees or getting some form of status to remain in the UK are also being supported, as you say, by the destitution team, making sure that they have what they need to get through the pandemic. They might be taking part in the drama groups or the creative writing that we've been doing, all of which is sort of giving them a community to be part of, and hopefully supporting them along the way in all the different ways that our refugee friends need. And I think it's something we can be hopefully very, very proud of, and I think gets a lot or gives a lot to our refugee friends as well. And I think I hope that that's been shared through these sorts of events, that we're able to share a little bit about how our mission to Accompany does sort of reach out into different aspects. I think we've got a time for a couple more questions, maybe one or two if anyone does have them. So put them in if you do have them. As I say, we have had a previous session on the asylum system and how it works. I don't think it's currently on our YouTube page, but we'll be hoping to upload that in the next few days, so you can catch up on that if you've missed that. There's also many other ways, of course, that you can find out more about the work of JRS. Obviously, our website is a very good place to start, so www.jrsuk.net. On there you'll find not just the news of what's going on at the moment, and different ways you can get involved, either through volunteering or supporting the work of JRS. You'll also find blogs and other pieces, comment pieces about some of the issues and legal problems our refugee friends face, and a wide range of issues that tap into the different things that we do at JRS UK. You'll also find some very important information about the new plan for immigration. You may have seen the government recently put forward some new plans for the immigration system, and we think that a bill is due to be coming to Parliament next week. So there's going to be a lot of important advocacy needed in the coming weeks and months, and we will really be relying on your support as supporters of JRS to raise your voices in support of our refugee friends and other refugees and people who are fleeing in search of safety that have yet to leave their homes and may enter the system in the future. So it's very important that we have all of us joining our voices together for that. We don't appear to be having any more questions, which means that we'll probably finish on time, which is lovely. But if you do have any questions or things come up, perhaps you might want to take a look on our website, as I said, to find out a little bit more. And we're very, very grateful for Michael and for Jess for giving up their evening to come and share a little bit more about their work in the legal project. As for what's ahead with the Accompaniment in Action series, we're actually having a little bit of a summer break and a summer sort of hiatus, as we know people will be going away on holidays and things like that. So we're going to take a little break, but we're hoping to come back in some form, probably in September, but keep your eyes peeled. And in the meantime, you might want to subscribe for our regular email updates. I can see Michael's
There's a question.
I've got another question. There we go. I'm too busy wrapping up that I'm not taking it.
Francis. Okay, we had 3 decisions on fresh claims, on actual fresh claims. Is that right, Jess?
Yes.
Three actual decisions on fresh claims. Those aren't all the applications we've made, and they're not all the decisions we've made, but on actual fresh claims, 3 decisions, 2 grants of refugee status and 1 refusal with a right of appeal so far. And so obviously the 2 we put in, they were refugees. They were definitely refugees. The 3rd person is also a refugee. I think we got a decent chance at appeal. We referred that out, as I said, because some cases will need a legal aid contract to spend some money on them, and that one will, to deal with some of the points the Home Office raised. But I think we're fairly confident about that one having a reasonable chance too. But yeah, 2 out of 3, 1 right of appeal. I'm quietly happier than Mr. Lowe from the German football team anyway.
Thanks very much, Michael. So I think we'll wrap it up there. But the last thing I wanted to say was, if you do want to support the work of JRS, obviously, as Michael and Jess have said, this is an area where there has been a lot of difficulty in getting people the sort of legal advice and the help that Michael and Jess are able to offer. And we can only do that. We don't have a legal aid contract, as Michael and Jess have explained. We can only do that through the support of our supporters and through some grants and things like that. So if you are able to support the work of JRS, please do consider donating to us either on a regular basis or on a one-off basis. You can find out more about that on our website as well. But it's only through your generosity and your support that we can continue helping our refugee friends in this way. So with that, I'll wrap it up, and I'll say thank you very much for joining us, and I hope that we'll see you again soon in some way, shape or form. Good night.
Bye, thanks.